So, welcome back to the fifth installment of our summer series on diplomacy and international relations. We are really excited to get into today's deep dive.
Yeah, it's a big one today. Really foundational stuff.
It absolutely is. But before we get into the invisible architecture of global rules, just a quick reminder for you, the listener. Please take a second to follow the show on whatever app you're using.
Right, and definitely check out the Patreon link down in the description.
Exactly. I mean, subscribing on Patreon is basically how we keep the lights on around here, and it unlocks extra explorations for you. Plus, if you're interested in regional dynamics, you get access to our exclusive weekly and monthly briefings on Danish politics.
Which is such a great community to be part of. We always have fantastic discussions in there.
We really do. So let's jump right into the hook for today. When you and I, just regular people, think about the concept of law, there's always this expectation of immediate physical enforcement, right?
Yeah, exactly. You expect someone to show up if a rule is broken.
Right. Like, picture this. You're driving down the highway, maybe you're running late for work, and you push the speedometer like 15 miles over the limit. A radar gun clocks you, and boom.
The flashing lights in the rearview mirror. We all know that feeling.
It's the worst. But the point is, a police officer pulls you over, runs your plates, and hands you a ticket. The state actually observed a violation, physically intervened, and imposed a consequence.
Yeah, the hierarchy there is completely undeniable.
Mm.
You have the state above you, the law as their tool, and the officer acting as the enforcer.
Exactly. But the second we zoom out and look at the international arena, that whole vertical architecture just, well, it vanishes.
It totally disappears. There's no global police cruiser waiting to pull a country over.
Right. There's no world parliament passing binding global legislation, and there's no Supreme International Court that can just force a country to show up without their prior consent.
Which leaves us staring at this massive paradox.
Yeah.
I mean, it forces us to ask a really uncomfortable question. If a sovereign state with its own military and economy can just decide to ignore a rule, is international law actually law?
That is the perfect question, and it connects right back to our previous discussion on international relations theory.
Oh yeah, the classic divide.
Right, because if you look at the early realists, writing after the League of Nations collapsed and World War II happened, they looked at this system and basically said international law is a total illusion.
Yeah, scholars like Hans Morgenthau, they argued that law is just totally subservient to raw power.
Exactly. Like, if a state followed a treaty, it was only because it was in their national interest anyway, not because the law actually forced them to do anything.
It's just a polite fiction for them,
Mm.
a way to mask power politics.
But other theories, like the liberals and constructivists, they see it entirely differently, right?
They do. They argue that even without a global COP, the law creates this vital framework. It sets expectations, and those expectations actively shape how states behave.
So to really understand how that works, I think we need to strip away all the modern complexity. Forget the UN, forget nuclear weapons, let's do a thought experiment.
I love a good thought experiment. Let's hear it.
Okay, so imagine a very primitive, isolated village. There's no mayor, no village council, no police force patrolling the dirt roads.
Just anarchy, basically, but not violent chaos, just no higher authority.
Exactly. Political anarchy. Now, in this village, there are several parcels of land, and one family lives on each parcel, and they operate with total autonomy.
Okay, so they're all little sovereign entities.
Right, and they engage in bilateral relations. Maybe one family grows a ton of wheat and another family raises cattle, so they just negotiate a trade directly.
Makes sense, but what happens if something goes wrong? Like, what if someone diverts a stream that waters their neighbor's crop?
Well, the aggrieved family can't call the sheriff, because there isn't one. They handle it themselves. It's accepted that they can use proportional force to defend their property.
And the other families just stay out of it.
Usually, yeah. Unless their own water is threatened, or maybe they made a mutual defense pact beforehand.
See, when you describe it like that, it sounds like the law of the jungle. It sounds completely lawless.
Right, but is it?
No, because if you look closely, you see the proto-institutions of a legal system. You have borders. You have the concept of property.
And you have the sanctity of contracts in those barter agreements.
Exactly. You even have customary rules. Like, maybe when the head of a family dies, everyone just accepts that the heirs will honor the existing debts. Nobody voted on that rule. It just became an obligation over time.
Because they functionally need those rules just to survive next to each other.
Precisely. And this village is the perfect model for the traditional international legal order. Just swap out the families for sovereign nation-states.
So the states are the principal actors. They hold supreme authority over their own land, they trade, and they rely on self-help when things go wrong.
And the defining characteristic of these states, the thing that makes them the heads of their families, is sovereignty.
Sovereignty. That's a word that gets thrown around a lot. We should probably unpack that.
Yeah, it's foundational. The concept really matured in Europe between the 16th and 18th centuries. The big turning point was the Peace of Westphalia in 1648.
Right, after the 30 Years' War, because before that, Europe was just a tangled mess of overlapping loyalties, wasn't it?
Oh, an absolute mess. You could have a local lord and emperor 1,000 miles away and the pope all claiming they had authority over your specific town.
Which sounds like a nightmare for governance.
Total nightmare. So Westphalia streamlined it. It established that within a specific defined territory, the state has the final supreme say. No external power can dictate your domestic laws.
Okay, but wait, that brings up a massive logical wall. If every state has supreme final authority, how can they be bound by anything?
That's the million-dollar question.
Right, because if you truly answer to no one, international law can't be pushed down on you from above. It has to come from the states themselves.
Exactly. This is the idea that states are the masters of the law. They are only bound by rules that they actively and explicitly consent to.
Which brings us to a super famous historical case that really proves this point. The 1927 Lotus case.
Ah, yes. The Permanent Court of International Justice in The Hague. This case is legendary in legal circles.
It really is. Let's set the scene for the listener. It's August 2, 1926, just before midnight.
Out on the high seas of the Aegean.
Right. And a French mail steamer, the SS Lotus, is sailing along, and it violently collides with a Turkish coal ship, the Bozkurt.
And it wasn't a minor scrape. The Turkish ship was basically sliced in two and sank incredibly fast. 8 Turkish sailors drowned.
Just a horrific tragedy. So the French ship survives, they pull the survivors out of the water, and they keep sailing until they dock in Constantinople, modern-day Istanbul.
And I'm guessing the Turkish authorities weren't just going to let that go.
Not at all. The second the Lotus docks, Turkey launches an investigation. They arrest the French officer who was on watch, Lieutenant Demons, and they charge him with involuntary manslaughter.
Okay, so Turkey arrests a French citizen. France must have been furious.
Oh, they were outraged. France points to a core rule of the sea. Because the crash happened on the high seas, which belong to no one, a ship is treated like a floating piece of the country whose flag it flies.
Ah, so France says that collision happened on French territory.
Exactly. They argued Turkey was violating French sovereignty by trying a French citizen for something that technically happened on French soil. They demanded Turkey release him immediately.
But Turkey obviously pushes back. They say, hold on, your ship hit our ship. You killed our citizens. We have every right to put this guy on trial.
Right. It's a total stalemate. So they take it to the Permanent Court of International Justice. And the way the court rules is what makes this so important.
Because France's entire argument was that Turkey had to point to a specific international rule that explicitly allowed them to arrest a foreign national on the high seas.
And since there wasn't a specific rule saying Turkey could do it, France assumed Turkey's actions were illegal.
But the court basically looked at France and said, you have it completely backward.
They flipped the whole logic on its head.
They really did. The court ruled that because states are sovereign, whatever is not explicitly prohibited is permitted.
That is wild.
Right. The court actually wrote, restrictions upon the independence of states cannot therefore be presumed. So because France couldn't find a rule preventing Turkey from prosecuting, Turkey's actions were totally legal.
Restrictions cannot be presumed. That is a massive precedent. It basically means the default setting of the entire globe is total freedom of action.
Exactly. You can do whatever you want unless you've agreed not to.
But I have to push back on this. If a country is only bound by what it freely agrees to, and can presumably just withdraw that consent whenever this is an illegal system, it's an honor system.
It does sound a bit flimsy when you put it like that.
Right. It's like playing poker, but the rules only apply to the people who are winning, and anyone can just change the game if they draw a bad hand. How do borders stay stable? How does trade work?
Well, the realists would agree with your skepticism, but there is a glue that holds this honor system together, and it's a customary principle called pacta sunt servanda.
Which means?
Agreements must be kept. It is the absolute bedrock of international law, and it doesn't exist because states are morally good. It exists out of sheer functional necessity.
Let's take that back to our village analogy. If one family is constantly breaking promises, like they take the cattle but refuse to hand over the wheat, There's no sheriff to arrest them.
Right, but the consequences are still huge. The other families will just embargo them.
Exactly. They won't trade with them. They won't respect their property lines. That rogue family becomes a total pariah, and survival gets incredibly difficult.
The exact same thing applies to nation-states. The cost of isolation is almost always worse than whatever temporary benefit you get from breaking a treaty.
Because even a massive superpower needs to use foreign airspace or export goods or protect its diplomats.
Yes, if a state gets a reputation for violating treaties, foreign investment dries up. Sanctions hit. The whole system relies on horizontal pressure from the community, not vertical pressure from a boss.
Okay, that makes a lot of sense. Now, I want to pivot slightly because we've been talking about this through a very European lens.
Yeah, we mentioned Westphalia, friendships, European judges in The Hague.
Right. And there's this really pervasive narrative out there that international law was basically invented in Europe, codified by Western philosophers, and then exported or, let's be honest, forcefully imposed on the rest of the world.
That narrative is everywhere, but it's just historically incomplete. If you look at it that way, you're ignoring incredibly rich legal traditions from outside the West that existed millennia before Westphalia.
Exactly. Like the idea that only Europeans knew how to draft a binding treaty is just factually wrong. Look at the ancient Near East.
Oh, the Treaty of Kadesh?
Yes. Signed around 1259 BC, you have the Egyptian pharaoh Ramses II and the Hittite king Hattusili III. They fight this massive bloody battle. It ends in a stalemate, and they realize perpetual war is going to destroy them both.
So they don't just agree to a ceasefire. They draft a highly sophisticated, legally binding treaty.
And it had everything: mutual non-aggression, alliances against third-party threats, even rules for extraditing political refugees. And they inscribed it on silver tablets in both languages.
That is statecraft and international law at an incredibly high level over 3,000 years ago.
And we see it in the Islamic world, too. Way before the Geneva Conventions, Islamic scholars were developing CR, which is the Islamic Law of Nations.
Yeah, back in the 7th and 8th centuries, jurists were writing massive treatises on how to conduct war, how to treat prisoners, and how to protect diplomats.
And that framework governed relations all across Persia, India, the Middle East, and even their dealings with Christian Europe.
So while the modern UN system is definitely rooted in that European Westphalian model, the actual substance of diplomacy and warfare limits is this global tapestry. It's a universal human endeavor.
And that endeavor has gotten infinitely more complicated since 1259 BC. When people hear international law today, they probably picture diplomats in suits arguing about nuclear weapons.
Right. The high-stakes political stuff.
But the reality is that the law has diversified so much that it's regulating the tiny details of your everyday life.
It really is. In the late 19th and 20th centuries, we shifted from a law of coexistence to a law of cooperation.
Because states realized technology was creating problems they couldn't solve just by respecting borders?
Exactly. Take something as mundane as sending a postcard, let's say from Copenhagen to Tokyo.
Oh, in the 1800s, that would have been a nightmare. You'd have to pay the postal service of every single country the letter passed through.
Doing currency conversions at every border. It was terribly inefficient. So states fixed it by creating the Universal Postal Union in 1874. They pooled their sovereignty to make one seamless global postal network.
And we did the same thing with civil aviation. When you get on a commercial flight today, the fact that the plane can safely fly through foreign airspace and talk to foreign air traffic controllers in standardized English is all dictated by the 1944 Chicago Convention.
Right. States have created over 5,000 intergovernmental organizations to handle this stuff.
Which brings us to a super relevant dynamic, especially for listeners following Danish politics. How does a modern state like Denmark navigate this? Because we're not just talking about global treaties now, we're talking about regional law.
Yeah, and the European Union is the most advanced example of this in the world. It operates on a concept called supranationality.
Meaning it sits above the nation.
Exactly. When Denmark joined the EU, it didn't just sign a normal treaty. It entered a legal order where EU institutions like the Commission and the Parliament can make laws that apply directly inside Denmark.
Which totally scrambles that old Westphalian idea of sovereignty. Under the old model, the Danish parliament would have to manually pass a domestic law to implement an international rule. They were the gatekeepers.
But in the EU, that gatekeeper role is bypassed. Because of doctrines like the principle of direct effect, an EU regulation on, say, data privacy automatically becomes law in Denmark the day it passes.
And it grants rights to Danish citizens immediately. Plus, EU law holds supremacy over conflicting national law, right?
It does. If the Danish parliament passes an environmental law that violates an EU directive, Danish courts actually have to set aside the national law and apply the EU one.
That is a huge surrender of that supreme family in the village authority. Why would a sovereign state voluntarily agree to that?
Because it's a strategic pooling of sovereignty. Denmark knows that in a globalized world, isolation is a massive weakness. You can't manage climate change or compete with the US and China unilaterally.
So they trade some domestic autonomy for immense regulatory power and market access across Europe.
Exactly. Sovereignty isn't this brittle shield anymore. It's a resource you invest in institutions to get better security and prosperity.
That perfectly frames the modern law of peace. But we have to talk about the darker side, because this cooperative web tears frequently.
It does. And when diplomacy fails, the law of peace is replaced by the law of war.
And historically, international law didn't even view war as illegal, right? It was just a legitimate tool. If you wanted a neighbor's territory, you just went to war.
Right, it was a sovereign prerogative. But today, the legal framework around conflict is divided into two Latin categories, jus ad bellum and jus in bello.
Okay, let's define those for the listener, starting with jus ad bellum.
Jus ad bellum is the law regulating the actual resort to force. It dictates when a state can legally start a war. And the UN Charter basically revolutionized this after World War II.
Because Article 2 of the Charter outlaws using force to conquer territory, right?
Yes, a general prohibition on the use of force. But it's not absolute pacifism. There are exceptions.
Self-defense being the big one.
Exactly. Under Article 51, if you suffer an armed attack, you have the inherent right to shoot back and defend yourself until the UN Security Council can step in.
And the other exception is if the Security Council itself authorizes force to restore peace.
Right. But once the fighting actually begins, regardless of whether the war is legal or illegal, a totally different set of rules kicks in. That's jus in bello.
Also known as International Humanitarian Law, or IHL.
Right. And IHL doesn't care who started the war. Its whole purpose is to regulate how the war is fought. The idea that even in the ultimate brutality of combat, there have to be limits.
And the catalyst for modern IHL is actually a very specific, crazy historical moment.
Oh, Henry Dunant at the Battle of Solferino.
Yes, it's 1859, and Dunant, the Swiss businessman, is just traveling through Italy, and he stumbles upon the aftermath of this massive battle.
He saw something like 40,000 dead and wounded soldiers just abandoned in the mud. No medical care, nothing.
And the sheer preventable suffering just completely horrify him. So he writes this book, A Memory of Solferino, and it shocks European society to its core.
And that book directly led to the founding of the Red Cross in 1863, the very first Geneva Convention in 1864.
Which eventually expanded into the modern Geneva Conventions after World War II. And they dictate that you have to protect non-combatants, civilians, medics, prisoners of war.
And they ban certain weapons, too. Things that cause unnecessary suffering, like biological agents or chemical weapons.
But the problem today is that this neat division between war and peace has really eroded. We almost never see two uniform state armies declaring war on each other anymore.
No, it's all civil wars, proxy conflicts, terrorism, cyber attacks. The lines are totally blurred.
Which is why we've seen this massive rise in international human rights law and international criminal law, because traditionally how a state treated its own citizens inside its own borders was nobody else's business.
Right. Sovereignty was a shield. If a dictator massacred his own people, other states had no legal right to intervene.
But the Holocaust completely shattered that paradigm.
It had to. When the world saw a modern sovereign state use its bureaucracy to commit genocide against its own population, the legal system had to adapt. Had to reach down past the state and protect the individual.
Starting with the Universal Declaration of Human Rights in 1948, it basically said that you have rights simply because you are human and your government is legally obligated to respect them.
And parallel to that, we got international criminal law. If individuals have rights, then individuals, not just abstract governments, can be put in jail for violating them.
Like the Nuremberg trials, and later the tribunals for Rwanda and Yugoslavia in the 90s.
Culminating in the International Criminal Court, the ICC, in 2002. A permanent court that can theoretically prosecute heads of state for atrocities.
Which represents a massive normative shift. Speaking of which, how does a norm actually change globally? Like, how does torture go from being widely accepted to universally outlawed when there's no world legislature?
Constructivist scholars track this through something called the norm life cycle. It happens in 3 stages.
Yeah.
The first is norm emergence.
Driven by norm entrepreneurs, right? Like NGOs, activists, maybe journalists.
Exactly. They see a practice like torture, find it abhorrent, and start a campaign. They name and shame, publish reports, and try to persuade states to adopt a new standard,
And if they convince enough states, they hit stage 2, the tipping point.
which triggers a norm cascade. Peer pressure takes over. Early adopters tell the holdouts, if you want to trade with us, you have to stop torturing people. The norm cascades through the international community.
And the final stage is internalization.
Right. The norm becomes so deeply embedded, it's just taken for granted. It becomes just cogent, a peremptory norm you can never violate. Even states that secretly torture people will publicly deny it because admitting it would destroy their legitimacy.
The hypocrisy itself proves the rule exists. That is fascinating. But I want to do a quick simulated interview with you.
Oh, a role play. I'm in.
Okay, I want you to step into the role of a practicing international law scholar. We're going rapid fire. First question. If there's no global codebook, where do you actually look to prove what the law is?
Well, as a scholar, my roadmap is Article 38 of the International Court of Justice statute. It gives me strict hierarchy. Number 1, treaties. Has everyone signed a written contract about this issue?
Simple enough. But what if there's no treaty?
Then I move to number 2, customary international law, unwritten rules. I have to prove 2 things here. First, state practice, that countries consistently behave a certain way over a long time.
But habit isn't law. Like rolling out a red carpet for a president is a habit, but it's not a crime to skip it.
Exactly, which is why I need the second element, opinio juris. I have to prove states follow the practice because they psychologically believe it's a legally binding obligation. It's incredibly hard to prove.
Okay, second question in our rapid fire. In a major crisis, does this law actually stop powerful countries, or do they just do whatever they want?
The law doesn't have a physical force field to stop a tank, but it creates profound argumentative needs. Even a superpower can't just say, we invaded because we wanted to. They'd face massive sanctions.
And so they have to use the language of the law.
Yes. If they launch a drone strike, they have to frame it as preemptive self-defense. They stretch the law, but by invoking it, they force themselves into global forums where they have to prove their case. The law mitigates the brutality.
Brilliant. Okay, stepping out of the role play, that leads perfectly into our key takeaways. I'm going to distill this massive topic into 3 points for the listener.
Let's hear them.
Number 1, the basic architecture. International law operates in an anarchy without a global cop. It relies on state sovereignty, treaties, and custom. It's held together by the absolute necessity of pacta sunt servanda agreements must be kept.
Spot on.
Number 2, everyday relevance. It's not just diplomats in Geneva. International law is the invisible infrastructure of your life, from airplane safety to internet data routing, especially when states pool sovereignty like Denmark does in the EU.
Right, it's everywhere.
And number 3, diplomatic power. Legal arguments create those argumentative needs. They force states to justify their actions, expose them to scrutiny, and provide the only peaceful way we have to resolve global disputes.
That's a great summary. It's a dynamic, ever-changing field.
Before we sign off, just a quick reminder to hit that Patreon link in the description. Your support keeps us going, and those Danish politics briefings are waiting for you. Also, please rate the show 5 stars on your app. It really helps us grow.
And next time on the summer series, we're diving into international organizations. We touched on the UN and EU today, but next time we're looking at how these bureaucratic behemoths actually function and fund themselves.
I can't wait for that. But I want to leave you, the listener, with one final provocative thought. For centuries, this law only cared about states. But with the rise of human rights and criminal courts, the individual finally has standing. As global law increasingly pierces borders to protect everyday people, are we witnessing the slow death of Westphalian sovereignty? Could we be moving toward a future where the individual, not the state, holds the ultimate power on the global stage?
A total structural inversion. I love it.
Something to mull over until next time. Thank you for joining us for this deep dive. Keep questioning the architecture around you.